he called the officers here in my courtroom today pigs. He called and he's nodding his head up and down. So apparently he hates every law enforcement officer in the United States. All right, please stand up, sir.
Go get in your car and do your job, little doggy.
God damn!
Trolls are having a field day with what's going on with delete laws, Hendry, and flex your freedoms. And it makes me wonder about the motivations of people who seem to love cheering on the violation of personal freedoms, including their own. When state and federal laws and the arbitrary commands of law enforcement officers run afoul of human rights and the articulated freedoms spelled out in the supposed supreme law of the land, it seems contrary to the fundamentals of self-preservation to continue supporting the addition of laws that erode more of our rights. At the same time, balance is key. It's easy to drink the Kool-Aid and get stuck in the trap of the cult of personality. No matter how much you may like and support someone, never allow them to jump in the front seat of your mind and replace truth and reason. Your allegiance should only ever be to that which is right and to those who do what is right. If a cop does wrong, it should be called out. If an auditor does wrong or acts foolishly or imprudently, it should be exposed. This is trial attorney Patrick Darcy, and he gives his professional opinion on whether Chille de Castro can overturn his 2 convictions on appeal. And before I play what he says, Chille's lawyer, Christopher Oram, has already requested a hearing and appealed and made a motion for bail or, in the alternative, a recognizance release. There is a hearing set for Monday, April 1st at 8 a.m., and I'm sure the trolls will have a field day with this date. Here's some of what Patrick Darcy believes will happen during the appeals process.
Well, now that Chille has lost on his 2 counts and is in jail, let me just what I think is going to happen with this appeal, because I think he will appeal. First of all, he's dead wrong if he thinks the appeal will be decided within the next 6 months. No way. It's not a high priority case. It's a misdemeanor case. It's going to probably be 1.5 years before it's heard, but he's not getting out in 30 days. No way. Also, they would know that he's a flight risk because of the warrant that's out in Ohio that I'm told is out there. I saw that in a traffic stop. So getting him out on bond would be very difficult. He'd have to pledge collateral and security, especially with a bail bondsman thinking that he's going to abscond. So I think he's staying in jail.
This is what he's talking about from publicdocuments.com. There are 2 active warrants issued by both the city of Oregon and the city of Ironton, Ohio. One is for criminal harassment. The other is for resisting, trespass, and disorderly conduct. In neither case is there a victim. No one was threatened, no property was damaged or stolen. Nevertheless, there are 2 active warrants, which seems like it would diminish the likelihood of any kind of early release.
What about the appeal itself? A lot of people have a misunderstanding of what happens with appellate process. First of all, he is going to need an appellate lawyer. Appellate law is a completely different animal than regular trial work that I do. Appellate court is going to look at errors in law, errors in admissibility of evidence, testimony that was not supposed to be entered into the record. But before they get to that step, they're also going to be looking at whether or not the person complaining about it did what's called invited error. In other words, did they object on the record to this? If there was this was a very short trial, so the record is pretty small.
This right here is where Chille's lawyer might have hamstrung him. I don't recall a single objection from Michael Mee, but plenty from the prosecution. In the appeals process, they're just looking for errors in how the trial was conducted, not about who lied. It's not about looking for any kind of evidence. They're looking for errors that affected the outcome. If not objected to during the trial, it's usually waived. And it looks like the hearing to get Chille out of jail will again be brought before Ann Zimmerman. So the likelihood that she'll grant that seems slim to none. I mean, bruised egos stay bruised for a long time.
Let's just talk about what the judge did from an appellate point of view. From an appellate point of view, she said very clearly that she based her conviction on what she saw with the videotape. Now, was it a good idea for Chille to give the thumbs up and agree he hates all cops? She even said, look, he's nodding approvingly here. No, it's never a good idea to antagonize a judge when they're handing down a sentence. In terms of the sentence itself, it's in the midpoint of what she could have offered. So I warned about that, and I also warned that they could string them together consecutively in my other video. You guys have all seen that. I went out and told you what I thought would happen, and it pretty much happened as I told you it would. 6 months is a long time. Okay, that shocked me. That was harsher than I was expecting. I mean, the DA wasn't even looking for jail time in a suspended sentence, and the judge looked at the DA like, you got to be kidding me. So did the judge abuse her discretion? No, you're going to lose on that. I'm just telling you, you're going to lose.
And the reason you're going to lose is because the system and the people who work the system don't seem to be interested in justice. Habeas corpus may sound like a fungus growing in the flower bed in your backyard, but it has a deeper, more profound meaning. Literally from the Latin, it means show me the body. That is, the judge or court should and must have any person who's being detained brought forward so that the legality of that person's detention can be assessed. Was Chille's detention assessed in the light of fundamental rights or according to the accommodation of officer safety? I think we all know the answer to that question. In United States law, habeas corpus ad subiciendum, which is the full name of what habeas corpus actually refers to, is called the Great Writ. And it is not about a person's guilt or innocence, but about whether custody of that person is lawful under the Constitution. Common grounds for relief under habeas corpus, relief in this case being a release from custody, include conviction based on illegally obtained evidence, a denial of effective assistance of counsel, or a conviction by a jury that was improperly selected and impaneled. Let's face it, habeas corpus has historically been an important instrument to safeguard individual freedom against arbitrary executive power. Yet people fall prey to that executive power every single day.
The judge has wide discretion. Discretion isn't unbridled, as they say. There are limits to discretion. For example, discretion does not allow her to commit an error of law. In California, for example, if you want to file a 170.6 motion to disqualify a judge, you have to do it within, I think, either 10 or 15 days of being served it. The other thing is that Chille's antics in the beginning of the case, calling the marshal a pig, the judge could have held him in criminal contempt. Criminal contempt is any violation that's in front of the judge. But the judge warned him and decided not to. So that's going to count in her favor when people say she's biased.
And wrong or right, perception is everything. That a judge even has the power in a courtroom to arbitrarily declare criminal contempt just because somebody voiced an opinion when there is no victim is sobering. And it should be sobering since most black-robed tyrants are drunk on their own power.
What I heard was basically the lawyer arguing the defenses that Chille was going to offer, First Amendment defenses. Well, First Amendment defenses, those are pretty touch and go. I don't like those because this is a criminal case, not a civil case. And in a criminal case, you better have case authority like the judge asked for. You better have case authority that supports your position that this is an absolute defense to the charge.
Seems like there's plenty of case authority, not the least of which is Houston versus Hill.
It's not easy to do in the criminal arena. And if you say, well, and I saw people writing this, you can't criminalize a constitutional right. Yes, you can. It happens all the time. I'll just give you some obvious examples. You want to yell bomb on an airplane? Good luck. Your First Amendment doesn't cover you in an airplane. Okay? You can't yell fire in a theater. You've heard that cliche because it's true. There are limits to everything. There is no such thing as unlimited constitutional liberty.
See, I disagree with this assessment because I think it's mischaracterized. There is unlimited free speech. There is unlimited right to keep and bear arms. There is unlimited freedom of press. But freedom stops the moment your freedom violates the freedom of another, which means there's no freedom to do that at all. Yelling bomb on an airplane or fire in a crowded theater is an infringement on the life, liberty, and pursuit of happiness of others and doesn't fall into the framework of freedom. Not at all. I have no liberty to take another man's possessions, just as I have no freedom to cause a plane or theater full of people to trample one another in a desperate attempt to find the exit to safety. The fire in a crowded theater argument is based on a statement of false equivalence. In other words, yelling fire or bomb in a crowded place is not the same thing as calling a cop a doggy at a policing for profit, corporately incentivized traffic stop. And I would think this attorney should know that.
The constitutional test for you YouTubers out there that want to be lawyers, rational basis. Any rational decision by the government will be good enough to apply it as long as it's applied in a neutral fashion. Next is, there's a mid-level scrutiny and then there's strict scrutiny. Strict scrutiny is anything that would impinge on a constitutional liberty, and it has to be narrowly, there must be a compelling government interest. I didn't hear any cases discussed in the closing argument that would support a First Amendment defense. Now, Michael Mee said that he submitted them to the judge. It is in the record. The appellate court will do its own legal research and analysis on that. And there's the question of the admitted evidence. We only had 2 witnesses and only the cop was cross-examined. Chille wasn't cross-examined, which really surprised me. I mean, I would have had a lot of fun cross-examining him.
In a way, I can understand him saying this. On the other hand, that seems like a partial statement. I mean, why wouldn't he say the same thing about Officer Bork, who lied on the stand? I personally think cross-examining Bork would have been way more fun. Officer Bork, you've had years of professional experience and years of tactical training. You have a Kevlar vest on. You're armed. You have unlimited backup at your disposal. It's broad daylight. You can see that the man standing there has a camera and gives no indication that he's a threat in any way. You gave him 2 commands to stop talking to the driver and to step back. He complied with both, Officer Bork, but you lied and said he didn't. Are you seriously going to sit there and tell anyone who's ever going to watch this video that you were so scared that you feared for your life? Are you that much of a snowflake that you can't discern that this guy wants to hold you guys accountable? And that he has a great disdain for people who violate the law under the color of law? I thought you guys were the brave, thin blue line heroes. Do you realize you only attempted to apprehend the cameraman after he called you a doggy? Yeah, cross-examining Bork would have been a whole lot of fun. But this attorney only mentions having fun with the guy who, while mouthy, while he may be arrogant, while he may be what some construe as an a-hole, he was only exercising his rights. But you'd only have fun cross-examining him? Love for you to explain that one, Mr. Darcy.
So the appellate court's going to see, was the evidence competent? Was it admissible? Was it relevant? Were there any objections to it being admitted into evidence? And if not, how prejudicial was it? Would it affect the outcome? Next, there's a lot of other ways that you can admit evidence, even if you failed to object. Maybe there was a mistake and it shouldn't have been admitted, whatever. It doesn't change the fact that the parties that were in that tape were the ones that were narrating what happened. The cop was, yeah, that's me, that's him. Yeah, that's the distance, that's what I said. It's coming in a different way. It's coming in through direct testimony. Anyway, the tape, even though it got admitted, there was enough there, I think, independent of the tape to still convict him. The next issue would be the constitutionality of the statutes themselves. There's an uphill battle here. Trial courts required to uphold the statute because it's been declared constitutional. I've already gone through all of that in another video. If you guys have read and watched my videos, I gave you the cases, in fact, and I analyzed the cases. The Nevada Supreme Court has declared these statutes constitutional, and they have used officer safety as the primary motivation. So what did the cop do? He talked about officer safety. Now, there's a problem with what he said. He's given an inconsistent statement. He says that officer safety is the reason for the 21-foot rule, but at the same time, he also said he didn't think that Chille was going to threaten him, wasn't a threat to him, and that's why he didn't tag Chille with a more serious battery charge. So officer safety really wasn't the overriding concern here.
And yet, this is what Annie Zimmerman said prior to throwing a man in a cage for a half a year.
The problem with the argument that your attorney makes is it completely fails to consider the safety of the officer and the safety of the driver. The officer doesn't know who you are, and the driver doesn't know who you are. And you don't have any right to interfere with that officer doing his investigation and deciding if he wants to issue a ticket to this driver. But you did interfere with his investigation. You did interfere with his ability to do his job. You did put him in a position where he is concerned for his safety and the safety of the driver.
The next thing is would the appellate court be able to do anything other than punt? These statutes have been declared constitutional even without a minimum restriction on how far back you're supposed to stand from the cops. Now, there is no hard and fast rule, and maybe the Supreme Court doesn't really give a shit and won't even want to entertain that rule because it'll be one of these mixed questions of law and fact, and they just aren't going to give you a hard and fast rule that you got to be at least 10 feet back. Obviously, the farther back you are, the less of a threat you are to the cop. But just by being near the cop, you are a distraction, especially if he's worried about you. Here's what happened. I'm just going off of my instincts as handling this almost 18 years and 34 trials. This standby counsel thing is just an absolute disaster for a lawyer. I would never agree to this. And here's why, because now you're sharing command with the person who doesn't have the training you have. You know, TV is not how law is practiced. I'm telling you that Michael Mee is a fine lawyer. You should see his wins, okay? He's not new to this game. But let me just say it from my perspective. I got a client who thinks he knows everything and thinks he's smarter than me. He's smarter than everybody in the room. And he's not, okay? He's not. Never would I tell a client, okay, you can take over the case and I'll just sit back and watch you. And if you have a question, I'll help you with that. Never. A person who is untrained in that is going to flounder. It looked to me like what happened was Mee was supposed to step down and Chille was supposed to take over the case. But now the judge is coming back saying, no, I'm not going to allow that to happen. Now Mee's first chair again. And now he's off balance because when he thought he was going to be sitting in the background, now he's in the front line. And I think he was very uncomfortable with the whole situation. I don't think that he showed, I mean, when he was crossing his arms, I don't think these are the arguments that he wanted to make, but he has to do what his client wants. Bottom line is that I don't see this appeal working out too well. The deck is stacked. The Supreme Court would probably just simply punt back and say, we've already ruled on the constitutionality of these cases and that's it. And then force Chille to go to the Ninth Circuit. Now, if he goes to the Ninth Circuit first without trying to develop a record in the lower courts and the appellate courts, then he has less of a chance for them to even hear the case because they turn down over 90% of the cases that are given to them anyway. I think the convictions are going to stand. He does raise an interesting constitutional question because I do not like the statutes. But we'll just have to see. But he will definitely need legal representation for this because these appeals are difficult.
I'll leave Mr. Darcy's original link for you in the description below. We have a brand new design in the store we're really excited about. It's 3 things you don't mess with: my family, my freedom, and my guns. If you want to support the channel, grab a hard-hitting conversation starting design from the store. If you haven't done so already, subscribe to this channel, hit the bell notification icon, give it a thumbs up, share it with everybody you know. Don't forget to subscribe to my email list through my website, highimpactflix.com. If you want to support the channel further, like I said, grab a shirt, become a channel member, but more importantly, know what your rights are and exercise your rights. If you don't exercise your rights, you will lose your rights. And also remember, it's dangerous to be right when the government is so wrong. I will see you in the next video.